something that I don't like doing it to me in conferences, but still it's just because I think you can draw so much more from the paper, because I think the conclusion was downlet to me, because it brought it to a larger question about Jewish law and without enforcement, so we are led to storytelling. But I want to push you on the content of your argument. You raised the question of site-specific, and I thought this is raising a very interesting question for the law, and the modernization of the law, because part of this modernization question that we are facing today is this site-specific law, specifically with the question whether, for example, criminal law, which we used to think about it as site-specific, as belonging to a certain community through a certain solidarity and so forth, is becoming universal. You can judge it in third-party courts, not connected to the dispute at all. And we have it also in transnational law, this whole idea that law does not belong to a community, to a place, or to a time, and that it can just be like your legal transplants, all this idea. So I want to push you to this paper that you wrote actually has a lot to offer about what is it that we are losing when we are moving to a non-site specific law, and what does these stories that you tell us have to teach us about it? What do we lose? What is the process that we are seeing here? And so I thought that it's much more than the storytelling and the convincing power of law. It is about what is the importance of site-specific law.
How do I take comments?
So just a few minutes, maybe, Leslie, I very much enjoyed those remarks. I had a sort of just methodological questions of the sort. And I want to go back to this question about the storytelling in the Hasidic world as being a means of social enforcement that arises with modernity as a way to kind of counter a lack of power. But I want to then ask how you distinguish the storytelling of the Hasidim from what is an historical form, right? So there's always been this tension between transmitting norms in rule-like fashion versus transmitting norms as stories and exempla, right? That starts with the Bible, and certainly you have it in the Mishnah and the Talmud, etc. So it's a contested issue, and I guess what I want to press is it's retrieving what is a contested issue inside the tradition that seems particularly interesting in Hasidism, and how one might see that beyond a question of simply needing a new form of social control. And the second question comes just from being, somebody who's embedded in the American pedagogic classical common law system, which is how do we actually, and we've had conversations about this before, but how do we really distinguish, right, between a story with a judgment attached, which is what these stories of the Hasidim really are, right, and law, because what is a case? It's a story with a judgment attached. And that's really the way in which this notion of precedent has kind of played itself out, with biblical narratives becoming norms as we read them as embedded in some canonical work or retold by somebody with authority and therefore having an implicit judgment in it. And then we look back on it and look at this as a norm rather than a story, even though it's, right, so, the third point, I suppose, has to do with this question of the disappearance in modernity, because we're interested in this question at this conference, of the hypothetical imagination and storytelling with increased writtenness. I mean, that seems to be, at least, our studies of the common law, is that the hypothetical and precedents had the same authority, absolutely the same authority, right, until the 19th century, and then there's rupture.
I'm going to actually press you a little bit on some of the points that Suzanne just mentioned. You said that that this use of such storytelling reflected the emasculated state of Jewish law. But if you follow sort of Suzanne's approach, you go in the Talmudic period, they use this kind of exemplar. The biblical period, they use these exemplar. Talmudic period, they use these exemplar. Medieval Ashkenaz uses this exemplar, this kind of exemplar. So, is all of Jewish law emasculated in that sense? Why do we, exemplar is a common form. So that's first. The second is, you're presuming that the status of the cantor is great, and that status is being directed towards law. But in fact, as cantors were a suspect class in Eastern Europe. There's a whole Yiddish literature, a whole number of Yiddish novels about this. Mati Pessi, the Shalom Aleicham's last novel, Makor Baruch, which is a very important 4-volume work written by a major rabbinic figure, blames the Spanish expulsion on the fact that they chose their cantors because of their good voices. I could go on and on. But cantors are a suspect class. It looks to me like this is a story to build, to build the status of cantors rather than to give to give a boost to Jewish law in some fashion. And the third point I'd want to make is a question really is to what extent is this a law story at all? Or is this really a martyrdom story? So, I wasn't I'm not so embedded in the American common law system as I'm embedded in the American baseball system. And I grew up with Sandy Koufax. And Sandy Koufax didn't pitch on Yom Kippur. He pitched on every single Shabbat. He pitched on Sukkot. He pitched on Shavuot. Whatever the baseball season was during all those holidays. No problem whatsoever. But we were told he had this great moment of sacrifice. It was the World Series, and he didn't pitch on Yom Kippur. Is this just simply a martyrdom story? The cantor Yossi Rosenblatt doesn't give up his life, but instead he gives up a very lucrative contract.
So thank you. Thank you for the comments and the helpful feedback, and for the opportunity to the organisers for inviting me. I appreciate your response, Joseph. I think your comment about considering the sacred is very helpful, and I certainly will take that into account when I reread and relook at my paper. As far as halakha not being the prototype of law and liturgy not being the prototype of art, I'm not sure what the prototype of either of those are. I think that certainly within the Jewish milieu, halakha was Jewish law was a prototype of law, and liturgy, certainly cantorial performances, I believe, was considered to be an art form. But perhaps I need to think about that again. Leora, I thank you for pushing me on the site-specific issue. Certainly something for me to consider. I think that would perhaps be a different way of looking at everything that I've presented here, and maybe that's a different article, which I'd be happy to consider. Because you pushed me, did something that you don't like people doing to you at conferences, I would just respond off the cuff. That I think that the key here, actually, Joseph provided for us by talking about sacred, and the moment and site-specific is connected to the performance being sacred, and as long as we look at law as not being a sacred event, so then we don't need it to be anywhere, we need it to be more functional. That's just my first response. I'm happy to consider that further. Suzanne, as far as retrieving the contested issue of the use of stories, I think that we generally think about Hasidic stories as a turn in the use of stories. And one of the questions that I'm asking myself is, well, how does this turn play itself out in law? So I've found examples, and I mentioned it in a note in the paper. I found examples of law appearing as obiter dicta. So, which is, what are they doing there? How are they retrieving it? How are they in conversation with the previous uses? I think it's a good point. It's certainly not, I admit, it's not fleshed out in this paper. and certainly could relate to that further. The disappearance of storytelling, the storytelling imagination with modernity. So I think that also is beyond my paper. We're actually finding that there are pockets of storytellers in the neo-Hasidic community. We don't find it so much in the Hasidic community today, but that's a story that remains to be described. I think that I've actually got an article coming out called "Tales of a Hasidic Tale" in the Journal of Jewish Thought and Philosophy, trying to grapple with that issue. But again, I think that's beyond my paper. Stephen, so as far as Cantor's being a suspected class, so let me just put that out there. I'm not a Cantor, so right, and I'm not. I know that there is someone in the room who told me that he confided in me that he is a Cantor, Asaf, and so by all means, of course, Cantors are a suspected class. This could be a story of martyrdom. Sandy Koufax is not part of my collective memory. That's not what I grew up with in Australia. So it's not. That wasn't what immediately I thought about. I thought about every Jewish boy growing up in Australia who wanted to play footy, Australian rules football, except all the games then were on Saturday. And of course, when they moved the games to Sunday, we all thought that was the Messianic era. I mean, that was the biggest sign that the Messiah was about to come, because games we could play football. I think that I accept your point that it is a story also of it could be passed as a story of martyrdom. I think the stories that I did bring though are internal within the Hasidic world. In other words, they're not coming as a critique from the outside. Samuel Rosenblatt writes his biography because he wants to say how great his father was. His father was also a very respected cantor, and he broke the mold of. You hinted at the critique of cantors, chazonim seinen naronim, the Yiddish term that cantors are fools, and Yossela broke that mold, and Samuel Rosenblatt is trying to build up his father's image. So I don't think that this is coming from the critique. The same with the story of Taub. He comes from within the tradition of he is a great cantor. So it could be presented. As a story of martyrdom. I'm not sure that these particular stories are part of that critique.
Thank you very much. It was very interesting. I would like to make a link between your paper and this morning's session regarding presumptions and truth. Now, as you mentioned in the paper, setting the Jewish calendar involves presumptions on reality, on some astronomical facts, and we know that sages knew that their presumptions are not real. We know it from the famous conflict between Rabbi Yehoshua and Rabban Gamliel regarding the Rosh Chodesh and Yom Kippur again. Now, in the case that you are describing, the tzaddik, Rabbi Taub, takes very seriously his role and his position in the reality. So he treats the calendar and he treats his job not as something flexible, but rather something that is real, something that can change the heaven and change all the angels and what they do up there. So it seems to me a little bit different than the view of the earlier sources regarding how do we look at these the calendar or its meaning. Now there is at least one source in the Yerushalmi, I think, that says the same. But my question is, if you agree, and in general, what do you think about the way that those rabbis, and in this specific case, both in this specific case and in general, the way that they saw their position, the way that they saw the reality of the calendar and liturgy around it.
So I really like this paper. I have kind of two questions, which maybe are related to my misunderstanding of the relationship of law and literature, or kind of this is kind of law and literature 101 type of questions. So one of them, again, it kind of is connected to this morning session. So it's interesting to compare the way you talk about storytelling and what Liora did with Oedipus. There, kind of the story is actually counter law, in the sense that kind of you've got law and then you've got the story, this art form, which kind of undermines our ability to judge because it's so complex. We've got the victim is also the victimizer, and kind of life art tells. Their art and literature is about undermining the ability to kind of judge people in a binary black and white way. Your storytelling is different. It's kind of a supporting kind of law. Story is supposed to support law. Maybe it's a difference between elite literature and folkloric storytelling. Maybe, I don't know. It's kind of, I assume somebody in law, I never took a law and literature course, so I assume somebody discusses the different modes in which law and literature are related. I assume, both exist, but the kind of thing, I think it's interesting to think comparatively about the various ways in which stories relate to norms, to legal norms, undermining these norms, also supporting them. Second question is, I'm not sure that it's so. I'm not sure it's very interesting the kind of law and society, or I don't know, jurisprudential argument at the end of a paper, where you say that basically in societies that do not have the power of enforcement, we've got stories that kind of perform the same function. Okay, but modern legal systems also rely you've got modern law, and then you've got newspaper reporting kind of stories about misbehavior of corrupt politicians or whatever, about rapists, about criminals, whatever, and they kind of coexist. So it's not as if these are kind of things. The storytelling is only something that you see in non-state communities that do not have the power to enforce the legal norms, and therefore resort to other kind of alternative means. It's something, it's universal. Every society has these, forms of social control. Sometimes you've got a functioning, positive functioning system based on positive law. Sometimes you don't, but always have a storytelling as another kind of method to kind of create social norms.
I have a question of pure ignorance. So I was this phrase, "Cantors are fools." What does it mean? Fool. What is the resonance of fool? Is this fool is this sort of contemptuous dismissal, or is a cantor a fool in the sense that the cantor speaks truth as a fool, as a Shakespearean fool, as a Shakespearean fool speaks truth? There is I'll stop there.
Thank you. Okay. So many questions. I want to ask, who's saying that this is site-specific, right? That liturgy is site-specific. To me, your stories are all much more gentle, and they tell us not so much about site specificity as about something. For example, the Hasidic tale is about non-commodification, if you will. And he also did record records, but did not go to the movies, right? So this is not really about liturgy being site-specific. It's about something else. So who is the person reading this as site? Is that you, or is that the way these things have been interpreted afterwards?
We should wrap up.
Which way? the other way
Done
around.
with questions.
My apologies, Ayelet. I'll start by answering Ayelet's question. Thank you.
I will ask my question. No, because
Antinomian, yes.
I in all these questions, which is about the compensatory model, where literature compensates for law and law. So, and let's put aside the emasculation and that kind of rhetoric, which is problematic in and of itself. But why do we understand literature as coming in to compensate for law? And I think that's something that has been done often, but I don't know that that necessarily. I'm done.
Thank you. Thank you again for another round of comments. I'll go in order. Avi Shalom. My comments were not about the historical Taub or the reality of the Jewish calendar. I was talking about what the use of the story was, and so therefore, and the sources you mentioned are in a footnote. So
yeah, but no, in this story, the image of Rabbi Taub, was it an image of a person that takes seriously all the issues that the sages did not take them so seriously?
So I think that I'll put that aside for the moment, because I'm not interested in this paper in how the sages dealt with the calendar. I'm interested in what the use of the story is, which I'll get to as I continue. Asaf, as far as, I don't know, a difference of elite and folk songs, folk stories, the paradigm I was suggesting using Shlomo Almog's literature alongside law as parallel tracks. Certainly, sir, I accept your point totally that the societies use different forms in addition to law. I think that's why I was referencing Ellickson, his notion of order without law, acknowledging that there are many forms. And I mentioned music, you mentioned journalism, which I think is very prevalent in our day. I was trying to highlight in the Hasidic milieu what were the media that were used to enforce norms, what were the forms, how did they achieve social control? And that's not taking away from your comment at all. Chris, as far as cantors are fools, so you mentioned, you gave the notion of a Shakespearean fool. The relevant parallel would be the Urodovi in the Slavic, the holy fool. Yeah. But in the Slavic milieu, which is where these stories come from, but that's not what that phrase means. That phrase, cantors are fools, is referring to something totally different. It's referring to the fact that cantors, when they would read the liturgy, they would be more focused on the musical composition rather than on the meaning of the words, and therefore they would pass the liturgy such that it would not necessarily make sense, or it even be presented as something ridiculous, rather than saying the Almighty kills and makes revives. They would say the Almighty kills. The Almighty kills, the Almighty kills, and revives. So the way that they would pass the words would change the meaning, and that's where the phrase, I believe, comes from. Anat,
and it rhymes.
Chazon in Yiddish.
Yeah,
Yes.
All Yiddish phrases have to rhyme.
Okay.
Can you say?
Chazonim seinen Naronim. That's the Yiddish phrase. Okay, Anat, as far as suggesting that it's site-specific, so that was my suggestion, and I can accept that if you would like to critique that. I'm not sure that the question here is non-commodification. The story with Yosela and what he did agree to do and what he didn't agree to do is tremendously complicated. I don't know. I don't have a rule. He refused to do opera. He did do vaudeville. He did benefit concerts. He recorded a memorial song after the Titanic drowned. What exactly was being done now? I'm not sure. Sorry, you're right there.
It's an interesting conversation. It's,
Yeah.
So you could tell the story the other way around.
By all means,
and
that's-
I'm wondering about the motivations of telling it this way, in terms of what it relates to. Okay, we'll continue that.
That's the way I read these three sources in concert, pun intended. but yes, I could see another way. As far, Ayala, thank you for your final comment. You said you're not, if I understood you, it was a bit rushed, you suggested that why do we need to go to the compensatory model? The reason that I can tell you the reason I've gone in this case to the compensatory model is for two reasons. One, because of the problematic state of Jewish law and the lack of effective enforcement mechanisms, and therefore I'm interested in how the traditional Jewish community enforced their norms or educated the people and ordered society. I think I'm suggesting here that in the Hasidic milieu, stories served that function in this period. That's one of my motivations. The other motivation is that I'm also trying to understand what's the role of the literature in this milieu, because it's generally understood to be there's a turn in the Hasidic milieu. There's new literature. There's new stories. Yes, it's a continuation of of a Jewish tradition of telling stories, but it seems to be a new form or a new emphasis, a new giving stories a new status. So I'm interested to try and understand what exactly are those stories. I think with that, I'll return to the chair. Thank you very much for your attention and your assistance.